People v. Lewis.
Good afternoon, Your Honours. David Fitzmaurice from Appellate Advocates for Mr. Lewis. I'd like to reserve 3 minutes for rebuttal.
Yes.
Your Honours, it's not every day that we see an attorney-client relationship imposed against the will of both the attorney and the client. And I would submit that the respective requests below warranted an inquiry by the trial court. Of course, the client's request in this situation, Mr. Lewis's requests, were in the form of pro se applications, approximately 5, during 2 separate proceedings. And I'd submit that the trial court clearly appreciated the nature of these requests and understood them to be requests for pro se.
So how is the request after withdrawal of the plea, how is that different than Duarte? He says, I would like to represent myself. How is that different from, I would love to go pro se?
So I think, I think that the distinguishing factor in Duarte is the engagement by the court. So when we think about Duarte, and actually Your Honour's decision actually quotes the exchange, the defendant says, I would love to represent myself. And the very next line of the transcript is the court saying, this matter is on for a Dunway-Huntley-Wade hearing. It's a non sequitur. Questionable whether it was even heard. Whereas here we have the court responding, so I would love to represent myself. You want to represent yourself? Yes.
But I think in Duarte we were also saying that it's determined by the facts surrounding, right, the circumstances surrounding the request. And I think your position is, at least to the second one during the plea, trying to take the plea back, that request. I think your position is, once he said, I want to go pro se, then that should have automatically, right, triggered an inquest.
A step 2 inquiry with phoretic colloquy.
And I'm saying that,
yes.
how do we view Duarte in that? Because in Duarte we said, look, you have to look at the surrounding circumstances. And here, if you look at the surrounding circumstances, I don't know that you could make a determination that it was completely unequivocal, because he's doing it in a slew of other requests that he's making in the middle of another hearing, and the judge says, look, we'll deal with that. Let's get through this now, and if you want to bring it up again later, you can, and then he never did. So like in making a determination about whether it was equivocal or unequivocal, I think you have to, and I think our court has said that you have to look at the surrounding circumstances. Do you disagree with that?
So there's a few parts to that, but where you left off, no, I don't inherently disagree with context playing a role. I do think the first part of context is the court's response, and I think when the court repeats the nature of the request, it's very clear that the court appreciates it as a pro se request, bearing in mind it's not the first request. There's been a request 7 weeks earlier, but even if the request from 7 weeks...
So when the court began to engage him, are you suggesting the court was making itself clear that he was in fact asking to represent himself?
Yes, Your Honour. And I think that to answer this question, and just Singh's question, to the extent that it harboured any reservations about sincerity initially in the June issue, I think that any such reservations had to be dispelled once it's renewed. And let's just take a step back.
The question of sincerity, is that go to the question of whether or not there has to be an inquiry? Isn't the inquiry only based on whether or not it's unambiguous?
Absolutely, Your Honour, but I just think that to the extent that maybe he moved on, in the June hearing, maybe he moved on to something quickly, and it that might look like Duarte. But when we think about the July circumstance, a plea withdrawal, this is an extraordinary example of something that might reinforce your desire to go pro se. I mean, Mr. Lewis tried to tell everyone that they were having his criminal history incorrect. None of the lawyers listened. No, his own lawyer didn't listen. The court didn't listen. The court said, this isn't relevant unless you go to trial and are convicted. So everyone's giving short shrift to his own views and his own knowledge about his own circumstances. Fast forward a few months, and it's vacated because everyone accepts, well, Mr. Lewis was right. I can't think of a better example than someone who already might have wanted to go pro se, being further confirming that notion, and the moment the plea was withdrawn.
But the issue at the first step, in order for the court to have a obligation to go further, is to determine if it is in fact an unequivocal request. There is no ambiguity. If there's no ambiguity, then you would agree that the court has an obligation.
Absolutely, and that's...
But if it's equivocal,
If it's equivocal, then you're right, it failed at step one.
Okay, so why is it not equivocal?
Well, because the court, he says, I want to go pro se, and the court says, you want to go pro se, and he says, yes. I mean, right there, that's step one. And
Well, isn't the next line what seals the deal for you? I'll deal with that?
so I think that this is the prosecution's claim that it was subsequently abandoned because it wasn't renewed at trial. And
Well,
to
can
that,
a judge actually do that?
absolutely not, Your Honour. A judge can't do that. McIntyre does not allow a court to defer something until trial. You know, but I'm not sure he's meant to make a 6th, 7th, 8th request. And also, we've had this conversation before, in a different case with People v. Dixon, where there was an issue about the prosecution and a potential Sixth Amendment issue with the prosecution listening to certain trial preparation calls during trial, and this court, might not agree with the decision, but this court's decision was premised on the fact that the defendant in that case had ample time prior to trial where the Sixth Amendment issue wasn't raised. So this court knows the importance of the right to go pro se, entailing a right to prepare a
But
pro se defense.
this court also decided People v. Gillian, and in that case, we said if the defendant is using a request so that he can get a newly assigned counsel, then it's not unequivocal. And I think this is what was going on here. I mean, looking at the transcript, he said, so I take my chance with a new attorney because this attorney is ineffective. And the judge says, I understand what you're saying. And he said, how long will it take to hire a lawyer? And he said, I would represent myself. So to me, that sounds exactly like Gillian.
Well, I think the important difference with Gillian is that a new lawyer was appointed, and then the pro se requests never existed again. There was no mention of it, and the court in Gillian felt comfortable that he was satisfied with the replacement lawyer. Same in Laval. I think in Laval, actually, the court says that everyone's ending with a smile on their face because the pro se request has been was more maybe a vehicle to kind of procure a change in counsel. Here, when he's saying, I'll represent myself, and the court's saying you want to represent yourself. I mean, this is step one. We're not analyzing what happened at a FREDA hearing. We're stuck at step one here, and I don't know what else you could do here to invoke step one.
So then he makes this request, and then there's a passage of time before the trial happens. So is it, in fact, correct? He doesn't go back. There are no letters written to the court saying, what about outstanding motions? There's nothing from the court bringing them back to clarify representation. Nothing happened?
No, the court, this isn't like a situation where the court said, we've just withdrawn your plea, I understand your request, we don't have time for a FREDA inquiry today, the next appearance will deal with it. By saying by saying literally, counsel's going to remain on the case and I'll entertain your application at trial, that's not the response to step one. As Your Honours mentioned, step one, the response is have the inquiry.
What's your, no, not at all. What's your view about the relationship between the request to go pro se and the trial attorney's request to be relieved? Are they freestanding, or somehow do they have some interplay between?
Well, they're freestanding insofar as both issues are completely without any support for what the trial court did and what the appellate division affirmed. But I do think you're right that
Well, I'm asking the question, not taking a position.
Okay, well, I'll take the position. Fast forward a few months, the other Sixth Amendment shoe drops, and now we have a situation where a defense counsel is asking to be relieved, which is another extraordinary situation because, normally requests for substitution of counsel, the whole framework is designed, or not designed for, but it has the moving party is normally the defendant. So this court had a situation in Fredericks recently.
But how could what happens later, the request to be relieved, bear on what the trial court did or should have taken from the defendant's request to go pro se previously? Well,
So they're freestanding, but I suppose when the court, to link all this up, when the court says, I'll entertain your request at trial, and faced with a request from counsel to be relieved, doesn't return to conduct the step two, I think that tells you that the court wasn't really seriously interested in entertaining this request, nor was it interested in entertaining counsel's request to be relieved. I don't think a response, I want to move this case and want to move this case expeditiously is an appropriate response when an attorney is telling the client or telling the court that they want to be relieved while referencing prior requests to be relieved. So in that situation, it's not like Frederick's, where, yes, a defendant is articulating issues with counsel, but at the same time, counsel is giving his own version and explaining, I want to stay on this case.
If it's clear, unambiguous, I want to represent myself, does the court have the right to just put that off for another day?
In the interest of being reasonable, maybe
Indefinitely.
not indefinitely, and not till trial. Whenever that happens, and it happens about 3 months later, it might have the ability. I don't want to have this court, you think I'm being too restrictive. Sure, it can put it off until the next appearance, but provided that appearance begins at step 2. And when it doesn't, I think we're in a situation where, if this isn't a clear pro se request under McIntyre, then step 1's starting to look different. I don't know what else he could do to request to proceed pro se. He doesn't need to make a motion. That's established. He's repeated it. He shouldn't need to do 6, 7, 8. How many times can he say it? Once the court repeats back to him.
I think the point is, though, if he's only saying it so that he can get some other relief or to get a postponement, then that's something that we could look at. You're starting at the point where he says, I want to go pro se, but you're not looking at the line above where he says, I want a new attorney. And when that's denied, then he says, okay, I want to go pro se. And then other times he said, you're not allowing the victim to come in and testify. I didn't want a jury trial. So can't the judge look at the totality of what's going on? Isn't that judge in the best position to decide whether or not this was a real request or a request to just delay an inevitable trial?
I would submit not at step 1. I would submit potentially at step 2. And again, we talked about People v. Dixon. In that situation, it was a request made in the alternative, which the court itself said, I think your request is equivocal, but we're going to go to step 2 anyway, and we're going to have an inquiry, and it ended up disentangling.
Let me ask you this. On this record, does it appear that the court was acting with the belief that the defendant had, in fact, asserted a right of self-representation?
That's a hard question to answer. I'm not sure what was...
Before trial, during the transcript, he says, he tells him, I'm going to basically, I'll paraphrase, put it off, and if you still want it, we'll deal with it later. Is that a clear indication that the court believes that the right had been invoked of self-representation, or that the court believed it was equivocal?
No, that to me, when the first time the court says, well, you made no motion to me, that tells you that it knows it's talking about pro se. And when the second time it says, I'll entertain your request at trial, we know we're not trying. This isn't Duarte where we're left wondering, did the court even hear it? The court knows what it's doing, and what it's not doing is following step 2 of McIntyre. So
your argument is the court can't just put it off and not address it?
No, that is exact. No, the court cannot do that. Yes, that is my argument. And I think that there's no harmless error standard that applies here, but and we could be here all day talking about the trial, but I will just say that what happened at trial is not the product of a functioning attorney-client relationship, and I think that the court never let either of these Sixth Amendment issues get off the ground, and I think that that requires reversal of Mr. Lewis's conviction.
Can I ask you one question that may not be relevant to anything?
That's why I'm here.
The defendant's initial lawyer was from Legal Aid.
Yes.
Subsequently, he had an 18B lawyer. Do you know what happened to Legal Aid?
Legal Aid is assigned at the arraignment, so normally they're automatically assigned unless you proceed pro se at the arraignment, which is the CPL provides a mechanism for, but it's not commonly invoked. You get automatically assigned a Legal Aid attorney. So then, really, the first attorney he's actually
the Legal Aid lawyer made the omnibus motion. Also.
Yes, quite a good one, yes.
Yes, and is that typical that after that you would then get replaced by an 18B lawyer in your experience?
Yeah, Yeah, I think that's when the first request would happen. Because you might not really even meet the legal aid lawyer, the arraignment lawyer, all that much. This is still very early in the case, and so he requests. And by the way, when he requests his first 18B, he doesn't mention pro se. He doesn't twin it. It's not in the alternative. He knows that there's a form for filling out requests for counsel. He fills it in. So he knows the difference. This request for pro se only emerges later after it's very clear that nobody's listening to him. And I think the plea withdrawal context is an extraordinary example of a desire, something that furthers a desire to proceed pro se. So
I'm sorry, are you saying that he had a legal aid attorney for arraignment only and then an 18B got assigned? Because I think it was several months later and actually after indictment that the second lawyer got assigned.
You're right, the legal aid attorney is automatically assigned and handled the omnibus proceeding, which actually resulted in a re-indictment of certain charges. But then he moves for reassignment and gets an 18B after the case is represented, during which time he's in Rikers Island on a misdemeanor. So,
But do you know why that happened?
No, there's no record of that. Thank you, Your Honours.
Thank you.
Good afternoon. May it please the court. On behalf of Queens District Attorney Melinda Katz, Assistant District Attorney Charlie Pollack for the people. Defendants' requests for self-representation were equivocal, and they merited no further inquiry from the court.
What's equivocal? I would like to represent myself. You're going to represent yourself? Yes. What's equivocal?
We have to look at the record as a whole. And so
Go ahead. What's equivocal?
So what's equivocal here is, are we talking about the June 4th? First on the June 4th date. So on the June 4th date, what's equivocal is
No,
that...
I'm actually looking at the withdrawal of the plea.
Oh, so, okay.
That's when he says, I would represent myself. Sorry, I would like to represent myself. That's now twice. You're going to represent yourself? Yes.
So on July 24th,
Yes.
at the time of the withdrawal of the plea, the request came after defendant first complained about the court's bias, then complained about his pro se motions not being answered. Then he said, if I'm taking this plea back, I want a new attorney if I'm going to trial. And then the court said, fine, when can you hire counsel? And then that's when he said, I'll represent myself.
But why isn't he the new attorney?
Because I'd say that's not a fair inference from the record here. He's clearly requesting a new attorney.
Go with your inference. Doesn't McIntyre and several of our other cases recognize that usually a defendant, or many times a defendant may seek to proceed pro se because they are dissatisfied with counsel? That would not be an unusual context. It's one we recognized in McIntyre.
Yes. Being dissatisfied with counsel is something that requesting new counsel and going pro se have in common, but they're different requests. And going pro se
Do you
is-
think the judge understood it otherwise?
I don't think the judge believed this was an unequivocal request because it
Because he
didn't
does say we'll deal with it later, right? We'll deal with it at trial, actually, we'll pick a jury.
It seems clear to me, first of all, in this context, it looks like, remember, he says, I want a new attorney if I'm going to trial, and then he says, in that case, I'll represent myself. It's not,
But what, you want us to consider the context.
yes,
Fair game. The court has said that.
that's right.
Okay, the court says, I'll deal with that. Mr. O'Donnell is on the case until you can hire another attorney. That goes to your point. But then he says, if you choose to go pro se at the time of trial, I'll entertain your application at that point. But Mr. O'Donnell, you're still on the case. So how can one read that other than to understand that the court appreciates that this is an application to go pro se? I'll entertain your application at that point.
There's two possibilities. One is,
And if there's two, why would you read McIntyre to suggest that you don't make it? This is just about a minimal inquiry. This is not that the court will agree to allow him to go pro se. We're talking about step one.
even if this were unequivocal, which I maintain it is not,
Yes, understood.
even if it were unequivocal, it's not written anywhere that the court must immediately spring into action and engage in that minimal inquiry.
That's fair, but why isn't this effectively a constructive denial? Because In the real world, if you tell a pro se litigant, I'm not going to tell you if I'm going to let you represent yourself until we're actually here picking a jury, what kind of position does that put the defendant in?
I think it's the opposite of a constructive denial. I mean, the words are, I'll entertain your application at that point if you choose to go pro se at
Okay, how
trial.
about
What
this?
person at trial, who knows what he's decided to do with the lawyer or not, is going to say, now I want to go pro se, and the judge says, okay, we're going pro se.
This
Go.
def-
Go
this
ahead.
defendant was not shy. And in fact, at trial, immediately before trial, he launches into another attack all about his disputes with his
You're
attorney.
right. He's not shy. But let me ask this. When you are going to have a trial, he makes it clear, I'm going to go to trial, I'm taking back my plea. You prepare for trial, yes?
Yes.
And here, does the court bring him back for a final pretrial conference or a preliminary pretrial conference prior to trial to clear up any outstanding issues?
No.
So how can one not arguably, as Judge Rivera said, consider it a denial?
Because he invited the defendant to raise this at the time.
At trial? Is it normal to, in my experience, it's not normal for any judge, quite frankly, to have a number of citizens appear in their courtroom for jury selection and then address the issue of representation?
I would say, Your Honor, that here, the judge, they're in the middle of a heated dialogue. It's reasonable for the judge to want to give the defendant a chance to reflect on that.
Fair.
And to make sure that this is a genuine request to
Okay.
represent himself and forego his
But is
right to
that
counsel.
the question at that first step? That sounds to me like the other part of the McIntyre inquiry. All you're deciding here is, did he make an unequivocal request? Then you proceed to the inquiry.
So
I think you're collapsing these parts of, the stages of McIntyre.
I'm trying to, I'd say I'm arguing them in the alternative, because I would say that this is not an unequivocal request, and therefore there was no burden.
So then the only way to view a request as unequivocal is if the defendant says nothing else but, I want to go pro se, regardless of whatever else is happening at that appearance?
No, Your Honor. The only way to know whether a request is equivocal or unequivocal, according to the cases from this court, is to look at the record as a whole.
So here in this context, what could the defendant have done differently in order for the request to be unequivocal?
Well, I think, first of all, putting it in the middle of a slew of other unrelated complaints, and then
I
immediately...
thought you just responded that you were not taking the position that the defendant couldn't raise other objections alongside the request to go pro se. Is the defendant required to only request to go pro se and can't raise any other issues with the court?
I'm not talking about requirements, I'm talking about looking at it holistically. So...
I understand, but if we're looking for some indicia, it seems to me that the notion that it is one of several requests, if that weighs heavily, it must be that you'd best only make this request and no other. But maybe there are other indicia you want to point to as well.
I can point to an example going the opposite direction, in People v. Dixon, for example. The first request there followed a request for reassignment to counsel, and then it was pro se, but it was followed by the judge repeatedly saying, for example, do you want to renew your application for substitute counsel? And the defense saying, no, I've talked to my family, we all agree that going pro se is the right way forward. So that would be an example. I'm not saying that's a requirement,
But
but that's an
here,
example.
You said there were some different indicia. One you indicated was that there were multiple requests. What else could the defendant have done differently other than make fewer requests in this particular appearance to communicate unequivocally the request for counsel, to go pro se, sorry?
I think there's certainly clearer ways of saying this, but for example, the example in Dixon is great. I've talked to my family. We don't want another counsel. This is the right way forward for me. I have an actual fixed intention, desire to present. I'm not saying there's any magical words. I'm saying we have to look at them.
So are you saying that perhaps, I'll go with what you're suggesting here for one moment on this, that until the moment he says, I would represent myself, perhaps he's not really thinking of representing himself. So when he says, I would represent myself, are you looking for something like, I've changed my mind, I want to represent myself?
I'm looking for anything
If
that
it
makes...
said that, no, if it said that, would that satisfy McIntyre's requirement that it has to be unequivocal?
I think it would help, yeah.
Well, why are you hedging? Why are you equivocal?
I'm equivocal because I'd want to, I just want to understand the hypothetical. It's the entire transcript is the same.
Except he says, I've changed my mind, I would represent myself. Sorry, I would like to represent myself. You're going to represent yourself? Yes. I'll deal with it, et cetera, et cetera.
I think that'd be a lot closer. I know I'm still being equivocal.
Yes, why isn't it past the line? When he said, if we take the earlier, right, I'm going with your suggestion. Of course, the court has said in Duarte, I don't agree, but about this context, take the context, say, before that, he wasn't really at all thinking of going pro se. It was not what he intended. But then once the judge says, how long is it going to take you to hire a lawyer? He figures out, oh, I can't do that. I've changed my mind. I don't want to hire a lawyer. I would represent myself.
I understand the question, and honestly, the reason I'm hedging, as you're
Yes.
quite accurately describing,
It's fair.
is because I think it would still give me pause that it's immediately following. I want new counsel at trial, and the judge saying, you're going to have to hire counsel.
Even though he's saying, I have changed my mind.
It still smells like leverage to me, like we had in
But
jail.
isn't
wait,
that,
wait.
that's the point, isn't that the other part of McIntyre? This is just about whether or not it's unequivocal, not whether or not it's genuine, not whether or not it's a delay tactic. Those are other parts of McIntyre. This is just this.
No, I don't think, I think under Gillian and Laval, that's not the other parts of McIntyre.
Okay.
I think that is the test for whether or not it's unequivocal. So
So is it one of the context clues that we were talking
Yes.
about earlier?
yes, exactly.
So if it follows immediately upon an unsuccessful attempt to substitute counsel,
It's a big red flag.
that's a indication that it might not be sincere or unequivocal.
Yes, that's what this court's case is
Do you
saying.
disagree that it would have been helpful if perhaps this had been explored more before the trial, before that span of time?
No, of course not. It'd save us all a lot of time here today. However, in Silburn, this court addressed that exact question, which is, if a defendant makes an equivocal request, does the court have an obligation to dig further and get to the bottom of that? And actually, in Silburn, the court said no. Maybe it's the better practice, but it's
Correct.
not it's not a violation of constitutional rights.
It avoids an appellate issue.
And that is what I'm asking, and sometimes not just because you're required, but in experience, I have found that it is simpler to take a few moments and go there. You bring it up, you've asked, I'm going to inquire about it, because the record belongs to the trial judge. I know one may not be obligated, but it certainly makes life easier.
I'm not going to argue that there are better practices or best practices that are not being engaged in here. I think the question is this a violation of his right, his constitutional right? Does this merit throwing out the entire trial and doing it over again? Because
all of these other things were going on. There's some things he said that one would argue were ridiculous.
not my words, Your Honor, but I don't disagree.
So there were a lot of things that were going on at the time. But the question, even as to those things, the transcript doesn't seem questionable with respect to the counsel, it's just left out there. The issue's just left. The court says, I'll deal with it later, and it's just left.
Well, the court says, the court invites him to raise it later, and he doesn't. And
So it's on him. He
I
can
think-
bring it up. The court doesn't have to rule right away or within a reasonable time. He can are you suggesting some kind of waiver?
I'm saying that there is, yes. I'm not suggesting it. I stated outright in our brief, there is some waiver. If he's invited to raise again later and he doesn't, there is waiver, and I've cited the cases in it.
That's not what McIntyre requires or allows. McIntyre is not a two-request rule. You made your request, the judge has to make an inquiry. Again, the judge might decide not to grant it. It's not about the grant or not.
But there, even in McIntyre's progeny, there are plenty of cases where it says that where even when an unequivocal request is made, that can be waived by the defendant if they don't act on it later, if they don't move for it later. And that's what we have here. And what we're left with is the next time the court meets, I see my red light is on, can I
Yeah,
finish?
please finish, yes.
The next time the court meets, defendant remains very vocal, remains very descriptive of his conflict with counsel and all the strategic differences they're having, but despite the court's invitation, does not raise his pro se request. And I should add, he then hijacks his trial halfway through and has two witnesses prepared that were his strategy. So as far as being able to prepare for trial, it seems he was able to do that as well, even though his pro se request hadn't been ruled on. So with that, Your Honors, unless the court has further questions, the people rely on their briefs. Thank you.
Counsel, could you pick back up where the people left off with the argument that the court didn't simply ignore, but invited the defendant to address the issue in the future if that was in fact what he wanted?
So, yeah, as we discussed, the fact that it's even making that invitation tells you that it appreciates it to be a pro se request. I think that what this is very like is, it's very like situation in Holmes. You know, in Holmes, which actually the prosecution attaches in their appendix, Holmes involved a situation where single sentence, I'd like to go pro se, was met with the court kind of conducting a Ferretta monologue, not a Ferretta inquiry. And this court said, well, if it's moving on, it clearly understands the request and it didn't conduct a searching inquiry, so this court sent it back down. And I think that's the situation here. Both courts understood the request. The only difference is rather than conducting an inappropriate Ferretta monologue, it just indefinitely deferred it until trial. We've already addressed how the right to go pro se entails an ability to prepare.
Did he have the opportunity to speak before the trial started about any outstanding issues that he had?
Absolutely, and speak he did, you know, which again, consistent with his desire to represent himself. I push back very strongly on the notion of hijacking a trial when what we're talking about is testifying in your own defense, which is one of the most core rights that a defendant has. But it's not meant to be impossible to satisfy step one. You know, as Your Honor alluded to, the origin of step one, McIntyre came along and it standardized the inquiry statewide. Step one, stop pro se issues being, you know, ambushing appellate courts. So let's make sure there's a clear and timely request. It's not very controversial. And I submit that this is not an example of ambushing an appellate court with a pro se request when he's made it on two different occasions, including immediately after withdrawing a plea. So I think the McIntyre framework applies to shy defendants and not shy defendants alike. And you know, I don't think that anything in McIntyre or any case following McIntyre allowed a court to understand the nature of the request, repeat it back, and to just do nothing. So I think that this is an example of a core Sixth Amendment right not being taken seriously. And to the extent that the prosecution claims that it was subsequently waived, the cases that dealt with waiver, the actual holding of those cases is that the defendant in those cases acted in a manner that subsequently indicated satisfaction with counsel. And I don't think there's a single universe where we can say that this trial reflected Mr. Lewis acting in a manner that indicated his satisfaction with Mr. O'Donnell. So if there are no further questions, Your Honours, I'd ask that this court vacate Mr. Lewis's conviction and remit the matter for a new trial. Thank you.
Thank you.